and welcome to Legally Speaking with me, Tarun Nangia. Now we commence our part 3 series on the PMLA judgment, which was delivered by Justice A.M. Khanvilkar, Justice C.T. Ravi Kumar, and Justice Dinesh Maheshwari. And there are some other issues, including predicate offense. And if a person gets acquitted in the predicate offense, does the PMLA and the ED cases continue? And the issue of search, seizure, taking possession of an asset. We are also going to delve into that. Of course, we dealt with the issue of the attachment of property, which Advocate Abhimanyu Bhandari explained what point came out in the judgment. So let me start with Senior Advocate Vikram Chaudhary. When we ended our part 2, Senior Advocate Amit Desai explained 2-3 points from the judgment, and I would like you to take over. And what was your point? And also, could you deal with if a person is acquitted in the predicate offense, what will happen? And secondly, I would also request you to deal with this point that merely, in a sense, committing a robbery or a fraud and keeping that money with oneself, will it also lead to a PMLA case? Or one has to launder the money for it to attract PMLA and project it as untainted money? Can you clarify that also?
Tarun, let me reiterate what I started in your earlier part.
Yes.
I said, well, this judgment is the beginning.
Yes.
This is actually the start of the road.
You mean a lot has to happen now after this?
A lot will happen in the coming few days. I'm not saying weeks or months, in coming few days, how this judgment is interpreted and applied. Yes, there are positives, many positives out of it. And one of them is, of course, as you said, well, everything will be proceeds of crime. The judgment has very, very, I would say, unequivocally asserted that not everything is proceeds of crime. Don't go on assumption. You have to, provisions have to be construed strictly, etc., etc. And then there are other safeguards. Arrest, there is safeguard. They gave you a safeguard while, say, in Section 50 also, part of it, they say the moment you become an accused, you are arrested, statement would be inadmissible. But as a student of law and as also a lawyer who argued on certain issues before the Supreme Court, I feel that, yes, if there was an area which needs to be revisited, well, there are 3 of them. I will mark it and flag it. So the first area that needs to be revisited is the revival of twin conditions. This revival of twin conditions, our plea, at least my plea before the Supreme Court, was that the amendment does not specifically resurrect or revive what has been already held to be ultra vires. And there was some law cited. The court has disagreed with it and said that, well, the twin conditions do get revived. But at the same time, yes, they gave a safeguard there also. There is no absolute restraint on grant of bail, and the court would look into broad probabilities. NDPS Act has been there since 1985, Section 37 twin conditions. Court has evolved a philosophy, and the court has a discerning sense when you come to superior judiciary, whether it is the session judges and when the constitutional courts like high courts come into the picture, they have a discerning sense as to which way bail is to be granted and which way it is to be refused. We have that engineering mechanism in place, but I would still like that this issue is tested, and we will see how it gets evolved any further than what has happened. There is a 3 judges bench. On certain aspects, there was already a 3 judges. Second area which I need to flag.
I like when you said that this is the beginning. Sorry to interrupt you, because I clearly remember 5 years ago, when the Nitesh Tarachand judgment was recorded, I invited you on Legally Speaking with Tarun Nangia, and we had recorded the show and we had heaved a sigh of relief that the twin conditions are gone. And then it was brought back. So to speak, so how much water has passed down the Yamuna since then? And so interesting times ahead as far as
never say never. It is going to be, there are certain areas. Second area is applicability of, say, CRPC or a procedural aspect to PMLA. Certain procedural aspects, as I said, are indeed opaque, whether it is the exercise of the power of arrest, recording of reasons, though in writing, but not to be shared as grounds of arrest, or the ECIR is not like FIR. Nobody knows what is in it unless the ED chooses to share. These aspects the court has again sounded a note of caution. There is a caveat actually in that judgment for everything that they've said. There is a caveat, there is a rider, there is an obligation cast on the enforcement directorate, etc. But at the same time, there is a great necessity to look into this in a more comprehensive manner. And as I said, within days,
a lot more is to come. I mean, you're holding back. I think Senior Advocate Vikram Chaudhary, you know more than what you're sharing with us right now. But I'll go to Advocate Abhimanyu Bhandari. I would request you to answer these 2-3 questions. Point 1, supplier of the ECIR. Now, does the judgment clarify that if the accused is the enforcement directorate bound to give the accused an ECIR copy on the basis of which his lawyer will argue the matter if a person is arrested, or the judgment leaves it to the discretion of the enforcement directorate that we may or we may not? Point number 2, if the fraud committed is of 30 crores and a bungalow whose market value is 60 crores has been attached, will the market value be considered, or will the value at which that bungalow was purchased will be considered? Point number 3, is robbery money laundering, or the money has to be laundered to be shown as, in a sense, money which is not tainted or earned from legitimate business activity? Can you please clear these 3 things?
So I'll take your last question first, Tarun. Your last question was that what is money laundering? And the argument that everybody made was that you have to project it as untainted property. That is an activity which is money laundering. Yes. The court has rejected that argument, and they've said no, dealing with proceeds of crime, dealing with possessing it or not possessing, if you're possessing it, sending it to someone else, buying an asset from it, is money laundering. So therefore, now there is no point repeating that old argument again. The court has categorically said that, even if you're giving that money, if X is giving it to Y, then that can constitute money laundering. So the money laundering offense has been, now there is a very broad definition. And we have to be very careful because, as I always said in your show.
Wait, I want some clarity here.
Yes.
One man has committed a crime and earned some money. Now he gives that money to a property dealer. Has that property dealer also committed money laundering by the impact that dealing with that tainted money?
Oh, so that's a good question, Tarun. The person who is given the money to the property dealer, the accused, he can get probably caught out by the act now, given the new judgment. But the person who's received the money and who's selling him a property should not come within the parameters.
Does he come within the ambit of investigation?
No, he doesn't come within the ambit of the act. Even this judgment clarifies that he doesn't come within the ambit of the act. There are various paragraphs. If you read them in the judgment, very clearly it says that the person to be accused of money laundering has to be associated with the process or activity of money laundering. So if X is giving 30 crores to a property developer to buy a piece of land or a property, then the property developer is giving consideration. This is not a sham transaction. He's actually selling a property to someone.
He can't be accused. He cannot,
certainly not, he cannot be accused of money laundering. So therefore, that is not what money laundering is. But yes, if the property developer gave a property worth 5 crores and took 30 crores so that he could keep 20 crores aside for the main accused, then of course the property developer also is involved in complicit in money laundering and therefore should be made an accused. And that's a natural consequence. Why not?
Point well taken. Point well taken.
But the problem here, Tarun, is that all these are issues which will be decided at the trial stage. The question arises, will you arrest that property dealer? You have the power now to arrest that.
That's the.
And if the authorities don't show the restraint to arrest that property,
but do they have the powers to arrest?
Of course, no. You see, it's today the authority may allege that the property dealer has taken 30 crores, knowing this is illicit money, and has given a property from.
So he can also be arrested. The property dealer can be arrested.
Of course, he has if that's the case against the property dealer, of course there is power to arrest the property dealer.
So in the whole chain, whoever has dealt with that money can be arrested.
No, only if that person with knowledge and the intention was participating in the laundering of that proceeds. So if the property dealer gave a property worth 30 crores to the person, then of course he cannot be arrested. But if the property dealer is complicit in some way, where he is given a property of much lesser value, then he can be. But let me tell you, the judgment also tells us one more very important thing, because when we deal with undisclosed money, the judgment says that if, let's say, authority comes to your house and finds that you have 10 lakh rupees lying in your house, that 10 lakh cannot be attached even if it is undisclosed income. That is a matter for income tax to charge you penalty.
No, but when ED, but when there is a statement from the ED that we have conducted raids and 30-40 lakhs were found, can they take possession of that cash?
No, of course, at that stage they can, if they want. That the ED will have to decide whether they feel
they have a discretion
of crime. Of course, they have to decide whether that is proceeds of crime or not proceeds of crime.
Okay, that's a wide discretion. That's a wide discretion.
No, but what the court says, court narrows the definition of proceeds of crime and says that proceeds of crime is a core ingredient and therefore has to be construed strictly, and gives an example that if you even find undisclosed income in someone's house, you can't attach all that money. You can only attach money which was derived or obtained from a particular criminal activity.
That's a very narrow definition.
So that's a very narrow. So for example, let's say accused X has 20 lakhs lying in his house. Yeah. 5 lakhs was from robbery of a bank. Rest 15 lakhs was his undisclosed income, which he has earned, but he has not disclosed it to the income tax authorities. What the ED can attach is that 5 lakhs, which has come from the scheduled offense, robbing a bank.
That's a very interesting.
Other 15 lakhs is undisclosed, for which income tax will take whatever penalty they want to charge on him.
Interesting definition.
Yes.
In further episode,
again, there is that check and balance which the Supreme Court has brought in. So that's what I'm saying, I said in the earlier part. There are hidden gems in this judgment, and if one looks at it very carefully, one will, for example, Supreme Court gives a very interesting example. It says, if a person is driving a car to go and rob, to commit a crime, you can't attach that car. That may not be attached. Are you getting my point? You can't treat that the fact he bought the car cannot be the proceeds of crime. The proceeds of crime is when it is generated from a particular robbery or from a particular...
Point well taken.
If one reads the various parts of the judgment, you will find interesting examples, and you will see that a large number of safeguards have been clarified. For example, this whole definition of proceeds of crime that has come in. I think it's a huge, it's a very good definition, because it says that everything is not proceeds of crime. You can't just have a roving eye and say everything is
point well taken. Now I'll take
very particular what constitutes.
Take this batch of questions to Senior Advocate Amit Desai. Now, even the many cases that you argue in court in PMLA, and you do a lot of those, I want to ask you 2-3 things. A, when you first go to court, is it the discretion, after this judgment, of course, is it A, the discretion of the ED to give you a copy of the complaint or no, which is the ECIR? Secondly, if the attachment happens, are properties in market value attached or the purchase value attached? Because we see a lot of news in the papers, this floor has been attached, that commercial property attached. What is this whole business of attachment after this judgment? Third is that if a person is acquitted in the predicate offense, will the ED case vanish into thin air and all the investigations stop and he'll be acquitted in the ED case too? These 3 points, if you could share with us.
So Tarun, let me clarify the position on the predicate offense. I think the Supreme Court has now settled the position, and there was a lot of ambiguity and, if I might say, a lot of misuse of the provisions of the PMLA, and now has settled it that unless there is a registered predicate offense, that means that there must be an FIR or by another authority, only then can the enforcement directorate now step in and start taking actions under Section 3 and Section 19. There's a very small caveat where they can act even without the predicate offense being registered, is if they suspect that there's a cash or some asset which is found and there is no predicate offense. They may go and attach the property and refer the matter to the jurisdictional officer, be it the police officer, any authority, and ask them to consider the question as to whether it's derived from a scheduled offense or not. In which case, temporarily they can attach the property, but they cannot take action under Section 19 for arrest or for prosecution under Section 3. It's only that otherwise. Now the Supreme Court, and this is a safeguard which now the Supreme Court has brought in and made it very clear that there must be a predicate offense. Now, the predicate offense is something which another agency will determine because they've got specialized skills, whether it is the CBI, which is dealing with corruption, whether it is SEBI, which is dealing with SEBI-related contraventions, customs officers, etc., etc. So they will determine the question of the existence of a predicate offense, and the ED comes in at the second stage. Now, if the predicate offense investigation results in a closure and therefore a discharge, or an acquittal or a compounding. Because, for example, if there's a private dispute between two parties, when they go and register an offense of cheating, and they ultimately settle the matter and they go for compounding or go for quashing. In all these circumstances, the Supreme Court has now said that if the predicate offense comes to an end, then the PMLA cannot continue. Now, this is a very important and a significant state observation by the Supreme Court. And because this was something that was being misused all the time, because the enforcement directorate officer would identify what he thought was a predicate offense and then commence an investigation under the PMLA and go around arresting people and attaching assets. That is something which now I think the enforcement directorate cannot do. And that's very, very significant. So when you say that, yes, if that predicate offense comes to an end, even by an acquittal, then ipso facto, the Money Laundering Act must come to an end, because that is the connection that the Supreme Court has made abundantly clear, contrary to a judgment of a Bombay High Court, where they say that the proceed of crime is directly linked to a predicate offense. It is derived from a predicate offense, only then does Section 3 come into play. So the moment the scheduled offense goes, then the link is broken, in which case Section 3 must fail. So this is something which I think was a very significant move by the Supreme Court and clarification by the Supreme Court in this area. So that's one part of the matter. You talked about the ECIR. I think that was, in my view, and as Vikram rightly said, I think all of us who are on this side feel very strongly about it, that when you're dealing with the criminal justice system, we understand the need for protecting evidence during the course of investigation. But when you take away personal liberty and statute and rights of parties, there is an obligation in the criminal justice system to bring about transparency, because the accused otherwise is fighting a battle with his hands tied behind his back, because he doesn't know what he's fighting. In the general criminal law, you always have an FIR, and that FIR is a public document which is made available to an accused, and therefore an accused has a sense of what the case is against him when he goes into court. Here was an opportunity for the Supreme Court to have clarified that, considering the very draconian nature of the legislation, that at least the ECIR must be made available if you are planning to take action of arresting an accused and bringing him before a court, because you're taking away his personal liberty. So you can't at that stage then say that, oh, I need to protect the evidence that is there in the ECIR whilst I take away somebody's personal liberty and he is sitting in jail. So that was the balancing that needed to be done when you dealt with the question of the ECIR. If you were not arresting a person and you were carrying on your investigation, there could be a debate, though my own personal view is, I think when it comes to the justice system, the document which commences the criminal investigation must be made available to the suspects and the accused in the case. This is one opportunity that I do believe was lost, and that's fundamental to any criminal justice system. The second opportunity that was lost, and I think Vikram adverted to it very briefly, but I think it's very important, is that the Supreme Court has consistently reinforced the principle in this act while upholding the constitutional validity, namely that there is a need for a reason to believe by a very senior officer before he takes certain actions under the act. That itself was identified as a safeguard. The safeguard is for whom? The safeguard is for the citizens. That is it's not the safeguard for the government. It's a safeguard for the citizens, and there's a reason to believe. But the real issue is that how do you ensure that that is a safeguard for the benefit of the citizens, unless you give that reason to believe, communicate the reason to believe to the suspect, to the accused, to the party who is affected. You can't determine whether the reason to believe is a mechanical process of writing out merely the section which remains in the closed drawer of a senior officer, because there's no ability for a party to agitate that this particular reason to believe is no reason to believe in the eyes of law. Now, this was in some ways a lost opportunity, because it's the Supreme Court, while emphasizing that safeguard, should have also considered that they should. In fact, there's a constitution bench judgment of the Supreme Court in a tax matter where they've said that the reason to believe must be handed over, and also Delhi High Court has taken over. So this is where I think another issue, an area where I think we should have seen it, and possibly as we go forward, as Vikram says, this is really the beginning. We hope that the Supreme Court will start clarifying and protecting the citizens by ensuring that there is a far greater transparency in the actions of the enforcement directorate, while balancing the needs of the state to protect the quality of some evidence from being tampered, etc. Just a quick answer on the last point that you just raised is the value of the property. I think the value of the property, when you're actually attaching the property, is really to be determined at the time. It's the judgment is silent on it. Let me put it this way. The judgment is silent on it. So there is again a scope for arguing that whether it should have been the original cost or it should have been the market.
Can I ask you a small question before I go to Senior Advocate Vikram Chaudhary?
Sure.
If a accused property worth 100 crore has been attached and there is an allegation that he's laundered 60 crores, can he appeal to the court that attach some other property? Why you're attaching this property?
Yes.
Because it's far in excess.
I mean, these are things which, let me tell you, the Supreme Court is silent on it. There are decisions of tribunals and other high courts where the courts have said that you should only attach that amount which has been laundered and no further. So if you have 60, if the property value is 100, but the property which is laundered is 60, then your ability to attach is only 60 and not 100. That position is settled by various other...
I'll not take this question to Senior Advocate Vikram Chaudhary because you've clarified that tribunals have held that...
and high courts.
Mr. Chaudhary, I want to know from you this. When the attachment happens of a property after the case is registered, if the attached property is not proceeds of crime, if it's an ancestral house, and if it is mistakenly attached, can you promptly approach the court and raise this grievance and get it deattached or you released from the clutches of ED? Or will that attachment be valid because the ED has attached that property? And has the judgment addressed any such issue?
I think, Tarun, the proceeds of crime use two different terms. One, they use the term value. And if the property is taken out of the country abroad, then they've used the term equivalent value. Now, there was a raging debate as to whether, supposing the property has not been taken out, and the proceeds of crime have dissipated, can you attach any other property of the equivalent value? Say somebody has been swindled 10 crores. You say, no, forget about that. I attach your another house, which may be ancestral. And this is 10 crores, so I'm attaching. So there's one judgment by Punjab and Haryana High Court Division Bench, which took the view that equivalent value expression is to be used only where the property is taken outside the country, and therefore it's not applicable. The SLP against that order also stands dismissed. And as I see this judgment, the present judgment, in 2 or 3 paragraphs, that concept has been upheld. That's what I feel. My first reading as a lawyer, as I said, as we progress in the next few days, how it is interpreted and applied is going to be a complex question. But yes, first question, equivalent value. When the legislature, parliament,
equivalent value can tell it.
Second, the question that you're asking, that assuming that somebody's property's value is 100 crores and the laundered amount is say 10 crores and you end up attaching the entire property, then the attachment is only to the extent of the value. But yes, supposing it's now, for example, a cement plant, it cannot operate because of the attachment, etc. You can always go to the writ court. Writ court is plenary jurisdiction of the high courts. They are courts of judicial review, ample powers to do substantial justice. And there are several writ petitions filed, several applications have been allowed where property is even substituted with some other property. People have offered that, assuming I will pay 8 crores as FDR, please keep it. Instead, please release the property.
That's a fair point. So courts are liberal to allow that. I'll go to Advocate Abhimanyu Bhandari. Now, could you address these 2 things for us? Point number 1, that if...
Tarun, before you ask me a question, there is a very interesting issue that has come up.
Okay.
While we are on attachments, we must clarify this. There's another very big breakthrough in the judgment. Before, what Tarun used to happen was that ED used to make provisional attachment orders when they used to feel that there is proceeds of crime. Okay. Right? And they used to file a provisional attachment order. Now the Supreme Court says that if you look at Section 5 of the PMLA Act, you can't simply attach proceeds of crime just like that. You also have to, in writing, have reasons to believe, which have to be recorded, that if you don't attach that asset right now, that asset will disappear, so that eventually, if there is a conviction, it will become infructuous. The asset will not be there. So now what has happened, this is a huge breakthrough, Tarun, because in many attachment orders, and you know, as Mr. Vikramjit and everybody will tell you, that in many attachment orders, if you look at the attachment orders, there are no reasons as to why, what is the urgency to attach. So for example, let's say someone is sitting in his house. Even if that is bought by proceeds of crime, you have to also give reasons that why you think that if you don't attach that property now, that property will disappear during the trial. And that specific reason has to be there. So if anyone, let's say, is trying to sell his house or is trying to part possession with his house, then I can understand that you want to give that reason to come and attach that property. But if those reasons are not there, and let's say someone is happily living in his house with no intention to sell, no intention to rent it out, and you have no reasons to believe that there's some kind of an urgency involved, then you can't even make an attachment. The court very clearly says that you have to satisfy both the criteria, 5A and 5B of the PMLA Act. This was a big confusion because Justice Muralidhar in J. Shekhar had said that you can't simply rubber stamp the language of 5B. And really, even after that, J. Shekhar's gone off travel to Supreme Court, and I think it's still pending there, if I'm not mistaken. I don't know, that first judgment. But what has happened is that this judgment is now clarified for once and for all that attachment is not just a mechanical manner that, okay, iske paas, he's got proceeds of crime, let's attach it. You have to show reasons that if you don't attach it, that property will not remain to be attached.
Point well taken. And I'll take this point to Senior Advocate Amit Desai now. The issue of possession is also discussed a lot these days, that the ED has taken possession of a certain asset, a property, a going concern. Under what circumstances can the ED take possession, and has the judgment dealt with it in detail, or has it not delved into it? Could you share that with us?
So I think that, Tarun, fortunately the Supreme Court has dealt with the question of possession in some detail, and I think it has come in favor of the citizens. I think the Supreme Court has very clearly said, while balancing and dealing with the question of safeguards, is that while you might attach a property, till there is a final determination of whether you are convicted or acquitted, you should not be dispossessed. Because what if you are dispossessed and then third-party rights are created and ultimately you are found acquitted from the charge? Then it becomes very difficult to turn the clock back. So therefore, the Supreme Court has now very clearly and categorically said that in all these cases, you need not take possession of the property, which is immobile property, until the end of the proceeding. It is only in exceptional cases, if the case is made out, that you might consider the question of taking possession of the property at an earlier point of time. So that position, I think the Supreme Court has done well to clarify it, because we used to see people, as Abhinandan in the earlier part said, that a lot of these cases where people's houses, they were occupying their houses, they would come and knock on their doors and say, time for you to leave. Residential premises, this is the only house of the family, and they were being asked to leave. So fortunately, therefore, now that possibility is clarified, and it's a question now of being honest to see, Tarun, as to how the Enforcement Directorate is going to digest this judgment, and how are they going to now deal with this issue regarding the emphasis on the safeguards. What has happened in the past has happened. And I think there are two parts to it. I think the noise is also about the question of the arrest. And I must say, I'm sorry, I'm going to come back to the question of the arrest, because I think that's something which is so fundamental to the citizenry of this country, that where we see in the last 1 month, 1.5 months, you had Justice Kaul and Justice Sundaresh dealing with the until guidelines and dealing with the question as to how you exercise the power of arrest. You have Justice Chandrachud dealing with the question of the exercise of the power of arrest in the Zubair case. The question really is that one has seen the use of that power in relation to the PMLA cases. And the question has always been, was it necessary to arrest these people? So long as the investigations could carry on without the custody of these people, that's the law. And the investigations, that nobody's interrupting the investigations. Why do you arrest the people? We've often tried to argue that the objective of arrest is really because, in 45(2), it's not easy to get bail. So this is where I think, as we hope that as time passes, the Supreme Court, and we have been hearing these noises from the Supreme Court, it's extremely concerned about the exercise of power of arrest by agencies. We heard just Chief Justice Ramanna speak at the program in Rajasthan, where he was concerned about the exercise of the power of arrest. We've had all these expressions of thought and concern from the Supreme Court coming out. I just do hope that this message is read and heard by the government, and particularly by the agency itself, and exercises the caution that is being recommended. In fact, it's a historical approach. But this is where I think the need of the hour in today, and if that doesn't happen, there's a need for the Supreme Court to immediately clarify directly in the context of PMLA, that whilst there is a safeguard under Section 19, the general principle on the exercise of power must be read into the provisions of the PMLA. As Vikram was saying, the question is, to what extent does the CRPC apply? because ultimately it is a criminal legislation. And then you deal with the question of 45(2). So, I mean,
Thank you so very much for sharing these
Tarun,
inputs.
I'll say one last comment.
Yes,
One
very
of the
quickly.
biggest legal luminaries we've seen post-independence, especially for my generation of lawyers, was late Mr. Jaitley. And Mr. Jaitley made a very emphatic speech, which is recorded in the press, when they were trying to bring in twin conditions in the Customs Act. And he said that there is no place for such twin conditions. So, with this hope that one day sooner than later we get rid, and the answer is not that these twin conditions are there in so many acts, so therefore it's justified in this act. I think that it is time that we start removing them from each and every act, because I think that our bail jurisprudence is strong enough to deal with those who should not get bail. For example, one of the real considerations while granting bail under the general law is the gravity of the offense. So that would ensure that people who've committed heinous crimes are not given bail, while those who are, in the periphery should get bail so that they can defend themselves and their liberty should not be sacrificed. So I think that it is time that we start thinking more on the legislature and on the government starts thinking more on doing away with such twin conditions in most of these acts, which contain them.
I'm going to just add one comment, Tarun, here, just last one sentence, if you don't mind. These twin condition principles evolved in the context of narcotics and terrorist legislations, where the punishments were life and death. It was in those extraordinary circumstances.
Not for these business activities.
Not for these kind of provisions. So that is
point well taken. But I think one interesting thing out of this judgment is the old adage which says the proof of the pudding is in the eating.
That's
now,
right.
How does the judiciary and the enforcement directorate consume this judgment and apply this judgment will decide what happens in future. As Senior Advocate Vikram Chaudhary said, a lot more is yet to come. So I think a month is a long enough time where we'll see how the ED acts with reference to this judgment, how the courts give or deny relief using this judgment.
We must not forget, Tarun, that the judgment is only dealing with validity of the provisions. It is not dealing with facts of any particular case. So the judgment is not to be read as an arithmetical or mathematical theorem. The judgment has to be applied to the facts of a particular case. And as and when every day new facts will emerge, the law will be expounded accordingly.
So we'll see this and we will revisit this issue with the same panel, hopefully in the last week of August. I think by then few cases would have been adjudicated upon, ED would have made arrests, some bails would happen. This case would be in a sense cited in courts of law. And of course, a review petition may or may not be filed. We don't know. But I think there is a month is a long time. We'll visit this at the end of the month. Thank you so much, Senior Advocate Amit Desai, Senior Advocate Vikram Chaudhary, Advocate Abhimanyu Bhandari, all three eminent advocates who appeared before the Supreme Court in this matter. And thank you so very much, viewers, for joining in.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.